Well, we learned today that the United States Supreme Court has two different kinds of justices. Justices who are trying to protect the Constitution and the law, and justices who appear to be trying to protect the president, specifically the former president named Trump. That is the fundamental dividing line that seemed to emerge on the court today, with Justice Samuel Alito, as usual, running away with wild flights of fancy about what would happen to presidents if the Supreme Court doesn't provide them with some form of new protection that has never existed before. Justice Alito was placed on the Supreme Court, in effect, by the Supreme Court. When the Supreme Court decided in the 2000 presidential election in favor of George W. Bush, who came in second in the voting of the American people, but came in first in a 5-4 decision in the Supreme Court. Because George W. Bush, who lost the popular vote and was awarded the Electoral College by the Supreme Court, became president, he was then able to put Samuel Alito on the Supreme Court. Samuel Alito, in his opinion overturning Roe v. Wade, quoted judges in England long before the United States of America existed, who were prosecutors of witches before they became judges, who were then in the business of sentencing witches to death as judges. Samuel Alito thought they were worthy of quoting, in his opinion, removing the right to safe health care services in this country for women. Today, Samuel Alito imagined that without some new form of immunity written by the United States Supreme Court, every future president will be prosecuted by the new Justice Department that takes over after the president leaves office. In making that prediction, Samuel Alito was able to ignore the entire history of the United States of America prior to the criminal rampaging of Donald Trump in the White House. Justice Neil Gorsuch, whose seat on the Supreme Court was procedurally stolen by Republican Senator Mitch McConnell, who stole it away from President Obama's constitutional right to appoint the justice, held the seat open long enough so that Donald Trump could put Neil Gorsuch in that seat. Neil Gorsuch, who should be embarrassed every time he takes his seat on the Supreme Court, joined in the invented scenario of every president being prosecuted by the administration of his or her successor forever in the future, even though that has only happened to one president, which proves that the one president those Republican justices care about is Donald Trump. They repeatedly tried to say that their entire concern was focused on the future, imaginary presidents, all of whom would appoint attorneys general who would become prosecutorial abusers of former presidents. Samuel Alito declared from the bench of the Supreme Court of the United States that the grand jury system in America does not work. It's one thing for flippant pundits on TV to use the overdone, cliched phrase about grand juries who will indict a ham sandwich if prosecutors want them to. It is another thing entirely for a Supreme Court justice to say that same thing, to use that pornographic, legally, ham sandwich example in the Supreme Court, which is exactly what Samuel Alito disgracefully did from the bench of the Supreme Court today. He willfully insulted every member of every Trump grand jury that has returned every indictment against Donald Trump. The team of judges trying to protect Donald Trump today came up against the newest member of the United States Supreme Court who was trying to protect the Constitution. Justice Ketanji Brown Jackson interrupted the questioning of Donald Trump's lawyer early in the hearing with this.
You suggested that the lack of immunity and the possibility of prosecution in the presidential context is like an innovation. And I understood it to be the status quo. I mean, I understood that every president from the beginning of time, essentially, has understood that there was a threat of prosecution, if for no other reason than the Constitution suggests that they can be prosecuted after impeachment. The Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to function and do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity. Everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution. No?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
I think
that if everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct.
Same with Donald Trump. Exactly the same. Later in the hearing, Justice Jackson imagined what could happen if the Supreme Court gives presidents even more legal protection than they have now.
If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes, I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say, no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
Professor Tribe, Justice Jackson seemed to be getting at the point that the Supreme Court actually doesn't need to do anything with this case other than to simply say there's nothing presented here for which Donald Trump cannot be prosecuted.
She is exactly right. And that was, for me, the pivotal moment. I mean, much of the argument was quite depressing in the sense that it really amounted to four justices, Kavanaugh, Alito, Gorsuch, Thomas, in search of a lifeline for Donald Trump. That was embarrassing. And much of it seemed to be kind of like a congressional hearing. They didn't want to talk about this case. They just wanted to spin hypotheticals in the air and almost draft a new law for some kind of immunity. But Jackson got to the point. All we have to do is our job, and our job is to decide the case before us. And on the facts before us, there is no plausible case for immunity. And if we take a step back, that's something the court could and should have done back in December, so we could now be maybe in closing arguments in this trial. So it is a shameful performance by the court, basically buying the very time that Donald Trump wanted. I do think, I'm just going to add, Lawrence, I do think that Neil and Andrew are right that it might be a silver lining, or at least a half silver lining. That is, if Justice Barrett's repeated point that we could decide this immediately and have a hearing quickly on the question of where the line between official acts and private campaign acts is drawn, and that kind of hearing would be one in which they wouldn't have to wait 88 days, as Judge Chutkan has said she would. If the case is sent back for trial someday, they could go right away, hold that hearing, and at least the American people before the election would see all kinds of evidence that, as Liz Cheney pointed out, the January 6th committee wasn't able to get. So that's a slight consolation.
I want to listen to one thing that Justice Gorsuch suggested in his wild imaginings of this world in which every president is worried about being prosecuted. And he wondered, wouldn't they all just pardon themselves? Let's listen to this.
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals. I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative.
Of course, there was no reason for anyone to think about it before Justice Gorsuch imagined it.
Well, Donald Trump has imagined it, no doubt, and he's probably surprised that his lawyer pretended not to have imagined it. Yeah, there's been a lot of literature about it. As Justice Jackson said at that point, come on, that's ridiculous. There's a principle hundreds of years old that nobody can be a judge in his or her own case. The court has never held that a self-pardon would be illegitimate, but that's a possibility. But the very idea that Gorsuch and actually Alito as well were kind of imagining the presidency as a bunch of crooks, typical, thinking the way the mob thinks. Oh, I'll just pardon myself on the way out. I mean, that just shows how pathetic it's all gotten. The so-called liberal justices were taking their job seriously. So was Justice Barrett. But the guys on the court, with the exception of the Chief Justice, for whom, like Neil, I always hold out some hope. He was a student of mine, and I sort of predicted that he would be the final vote to uphold the Affordable Care Act. I'm a little less sanguine here because he made a couple of comments during the argument suggesting that he thought the Court of Appeals had not done a great job, even though it was a unanimous bipartisan decision, quite brilliant opinion. He said he thought it was a little circular. So he clearly wants to do something more on remand. But the main point is they could have decided it all back in December. If they felt a need to weigh in, they didn't need to wait for the Court of Appeals at all. In case after case, the court has simply picked a case and decided it after the district court. They did that in the Nixon tapes case. They did it in the Pentagon Papers case. It's become a more common practice. But instead of doing that, they stretched it out. They rephrased the question to make it very broad, abstract, academic almost. And then they set the argument for the last possible day this term. It's really shameful because even though none of the 9 justices could, with a straight face, and none of them indicated they would, say that they agreed with the extreme Trump position that he's absolutely immune from any prosecution for what he does, however criminal, while he's in office. Nonetheless, even though that's going to be the bottom line down the road, for all practical purposes, if he's reelected and picks an attorney general who does his bidding, he won't even have to do this crazy self-pardon business. He will simply get rid of the case by having an attorney general who fires any special prosecutor who would keep the case going. And then, for all practical purposes, the president has absolute immunity for everything that he might do. And as Justice Jackson points out, we have a new crime center in the Oval Office. Anybody who wants to basically launder all of his or her crimes becomes president, probably by hiding embarrassing information, the kind of thing that's going on in the trial in Manhattan, becomes president, and then basically has a get-out-of-jail-free card forever.
I guess Clarence Thomas's idea of recusal is to just be the one who says the least, which is what he did today. Very few words, 3 questions I noticed, didn't take up more than a minute of the court's time each time.
Well, it's not so much what he's failed to say in the courtroom. It's what he's failed to say to any investigator, to his colleagues on the court, or to the public about what the facts are related to his recusal. And there's no place in the country where the rule of law, where due process never actually gets at the facts, except as to the Supreme Court and its own indiscretions and its own ethics problems. And so that remains a real problem. This is now the third case that Justice Thomas has sat on where he has completely failed to make any positive case for himself as to why he should not be recused. And the court itself as an institution has completely failed to inquire into those facts. And there is no other party working for the court, like an inspector general or staff attorneys or anybody else, who have made any effort to interview him and find out what the facts are. And that is really inexcusable in a country of laws. And thank you, by the way, for mentioning my announcement today. If anybody wants to join the fun, come to WhiteHouseForSenate.com.
Senator, what else did you hear in the Supreme Court hearing today that we either have or have not yet covered that you think actually should be the way the court looks at this?
Well, the part that aggravated me to come at it from the other direction was Justice Gorsuch very pompously saying that we are writing a rule for the ages here, as if he's some high priest of policy who's going to be making age-long determinations. No, there's a constitution. It says that the court is confined to deciding individual cases or controversy. The case or controversy here is, does this indictment violate any kind of immunity protection? This indictment. And instead, as you've pointed out on the show, Lawrence, they went on this long expedition through hypotheticals and through a lot of nonsense, with the result, and perhaps horribly to say, the intent of delay. And we'll see how quickly they respond. But you remember in Bush v. Gore, they decided that case the day after oral argument. When it was putting a Republican president in power, they didn't waste a minute. Now that they're protecting a Republican president by delay, we'll see how quickly they respond to this. But there's a lot at stake here. And just the arrogance of that, you know, they say that they're originalists, but they talk about policy as if they're legislators. They say they're minimalists, but they don't follow the language or narrow to the case or controversy. This argument has exploded so many of the pet theories of these justices that it's almost comical.
And they are willing to completely ignore 234 years of American history.
Yeah, that was the great point that Justice Jackson made. For as long as there has been in America, there have been presidents who did not enjoy immunity and who did not break the law. It's the justices who won't admit that the novelty here is, for the first time in history, a president who is likely a criminal. That's what's new here, not some new idea. And the idea that they have to look at every other presidency and future presidencies as potential problems when we have one presidency that was a problem, the presidency of Donald Trump, because of crimes he likely committed in office.